Well, thank you very much, President Mason. Always great to be here. I am the son of a John Jay alum. My dad, the late Edward J. Lewis, was NYPD officer who went here under a program that allowed cops to go here for free. And he did it while working full-time for the NYPD. And it took a long time, but he did end up getting a bachelor's degree. I'm glad to be here in part because this is a question that we have been talking about at Spectrum News New York 1 for quite a while, and in trying to both cover the news side of it, but also provide some analysis and some context to watch the narrative depart from the factual basis that we all hope it would rest on has been a challenge professionally and personally a little frustrating. You know, I mean, you spend a lot of time reading through reports from places like John Jay and trying to make sure that you have the numbers right and the facts right and the trends right and the percentages right, only to hear people, some in positions of political authority, say, well, none of that matters. Let's just use common sense, right? Let's depart from the facts and just, do stuff to people. It all reminds me, Senator, of a phrase that was very much in the headlines in the late 1980s called preventive detention, which is really what some people are calling for, which is very different from what you all had in mind. So let me just start by invoking the frequently quoted and misquoted, I'm probably misquoting it too, it's often attributed to Otto von Bismarck: if you like laws and sausages, you should never watch either one being made. But as one of the top chefs in the sausage factory, I would like to talk to you for a little bit about how this all came about, because among the things that are now departing from the facts is the chronology, the history, the legislative intent, I guess you would call it. Take us back to 2019. This is before George Floyd. This is before the nationwide protests. This was on the agenda. This was something the legislature was taking up and working on quite diligently, along with some other jurisdictions around the country. What was the intent? Why was this on the agenda? What made 2019 in particular a propitious or politically viable or attractive year to try and move this legislation forward?
Okay, thank you. And let me just take a moment to thank also President Carol Mason and Jeremy Travis for getting us together today, and you, Errol, for continuing to do the great job you do. I didn't go to school here, but I went to school right across the street at the Lincoln Center campus for Fordham, so it's a familiar neighborhood for me as well. As to your question, I'm going to take you back further than 2019. 2015 is when I introduced the bill to enact bail reform. Now, we were in the minority then, so it didn't have a lot of chance of passage, but 2019 was a momentous year in the state. We took the state Senate. We had two functioning houses that were passing laws of great import on so many issues. Most people today are most pleased with the fact that we codified Roe versus Wade in January of 2019, our first few weeks in the majority, and that is proving to be prescient, but we're not here to talk about that today. But the other thing that happened in 2015, which is why that bill got introduced, was a young man who spent years in Rikers Island unjustly killed himself, and that was Khalif Browder. Very high-profile case, but a case that is representative of hundreds and hundreds, if not thousands, of more people that entered the system. And we were committed to doing something to bring about justice. And then you take the 10,000-foot level thought about it, and like, what is bail? By definition, bail discriminates against the poor. You're asking people to pay for their freedom. And you don't hear any complaints about wealthy, awful people who do awful things in our home because they have enough money to be home. I was reading last year, the year before, I forget when it was, but I guess we're in the pandemic, maybe it was the year before that Harvey Weinstein was like at comedy clubs and out at restaurants. And why? Because he had enough money to pay bail while he's waiting for his trial and all the awful things he's accused of doing. Of course, young, poor people, primarily of color in this city, don't have that ability. And one of the things I had done, I've always been interested in criminal justice issues, and I've worked on wrongful convictions and other issues over the years. I've been in public service, but I also had volunteered with the Fortune Society to mentor people who were incarcerated at Rikers and try and help them integrate into the community once they come out. And it was eye-opening just to talk to these people and get their perspective. It's such a different perspective than you and I would have. Because I was asking one of the gentlemen I was dealing with, and I said, well, why, what happened to you? And he had bail set at some incredibly low number. It might have been like $500 or something, low for you and I. And he's like, I just never had a thought that I could round up that kind of money. So he's like, I'm here. And I just knew I was going to be here. And oftentimes, especially on low-level charges, these people are held at Rikers for longer than their sentences would be if they are actually convicted after trial. And the injustice in that is obvious, or should be obvious to everyone, especially in a system that we're taught from when we're children. We take great pride in the American system of justice, innocent unless proven guilty. These are all pretrial incarcerations we're talking about. These are people who are denied their freedom before they're convicted because they don't have enough money to pay for their freedom while they're waiting for their day in court. So if someone wants to defend that system, I'll have at it all day, every day with them, because that is unjust in so many ways. And then, of course, we set about trying to fix that. And the reforms of 2019, subsequently amended in 2020, and again this year, are our best effort to do that.
In New York, famously, the law specifies that bail can only be set in such a manner or according to factors that deal with whether or not the person will show up for trial. That immediately became sort of the touchstone of the opposition, as far as I can tell. What was that conversation like? Because, essentially what we have had, and this goes all the way back to the fights when they would attack former Judge Bruce Wright and others, softy judge that let this guy out, that sort of a thing, where it became clear along the way that some people did not see bail for what it was legislatively intended for, but basically as a sort of a tool to hold people that, for whatever reason, they thought should be preventively detained.
That's 100% correct. And bail in New York has never been used to, or the pretrial system, I should say, has never been used to make a judgment about whether someone is dangerous. And you hear about this dangerousness standard all over. But in New York, that was never in place. And so rewind 10 years, 15 years, everyone was so happy with how safe things were. We did not have a dangerousness standard in New York, so we know how to make the system work without that. Because, of course, the problem when you start evaluating that, a criminal trial is our system for evaluating whether someone committed the crime they're accused of. When you start evaluating whether someone is dangerous, when a judge and a prosecutor are evaluating whether someone is dangerous before they've even been adjudicated, the consequences, as data will show, have a horrible impact on particular classes of people, typically young people of color, again, who always seem to be getting the short end in our system. And it is not something that we need, we ever had, or actually makes us safer.
Is New York unique in its adherence to that standard of, only to ensure appearance at trial and essentially no other reason?
Yes, in a word, yes. I mean, we are maybe one of the few, if not the only state that does not consider that.
Yeah. When you began drafting legislation in that period, 2015 up to 2019, was there serious consideration in the legislature about doing away with that standard, about bringing New York in line with the other 49 states?
It has the reform conversation, the legislation took a lot of different forms over the years, and a lot of different ideas were explored. The original draft of the bill eliminated bail for everything across the board, take money out of the system entirely, and it wasn't a dangerousness standard, but it did have some mechanism for determining when remand was appropriate, not based on theoretical dangerousness, which to me sounds like, the pre-crime evaluators in the Minority Report, right? Like there's obvious problems with trying to predict when someone's going to do something when they haven't actually done it. But for me, the dangerousness standard is a problem and always was a problem, and it's a problem in the states that have it. Some places now say they have algorithms to make proper determinations, but then you could, you could dig into this 7 different ways. At the end of the day, what tends to happen is the same people who are always getting screwed by the system end up getting screwed by any type of predictive model as to whether or not they're going to be dangerous on the street. And yes, for every New York Post headline about someone who did something awful or is accused of doing something awful, there's dozens of more who have more stable lives because of what we've done, who are home with their families, who get to keep their jobs while they're going through the system. And that ultimately makes us all safer, which is another part of this that really gets at me. It does not help anybody. It doesn't help the people, certainly, who are incarcerated. It doesn't help our communities in general to take somebody, put them in Rikers for several months or a year or however long they're waiting for their trial, and then release them back out into the community. What's happened in the meantime is they've lost hope. They've lost their families, they've lost their jobs, they've lost their school opportunities, and then you're throwing them back onto the streets without any ability to provide for themselves. And then you're more likely to have them commit additional crimes or do things they shouldn't be doing. So none of this makes sense to me, and ultimately, I don't want to filibuster, I want to let you get in with your question, but what has become clear to me over the last couple of years is there is just, our legal system is adversarial. Each side makes its case. Prosecutors are not supposed to be in an adversarial posture. They're supposed to do justice, whether by acquittal or conviction. But in fact, they're adversarial. And they sit there and they count how many people they put in jail, and they think that's a good thing. And usually they're in league with the law enforcement. And they are defending their turf, so to speak. And their turf is, we want more people in jail, and we want to keep people off the streets who they might deem are unsafe.
Was that the process as you were drafting the legislation? I know there were, lots of hearings, lots of people who weigh in, the lobbyists, have your phone number. The DAs, I imagine, weighed in, maybe the sheriffs, a lot of other law enforcement?
And I don't want to paint with too broad a brush. There were some DAs who were very productive in terms of the suggestions they made and were genuinely interested in getting us to a good conclusion. But writ large, the law enforcement lobby, so to speak, and look, they're very effective. They're the reason we're standing here today talking about why this issue has been so misunderstood, is between them and the editorial boards, they just are relentless. And what's happened is, because crime has gone up, not at all related to bail reform, by the way, because it has gone up in every city and every state in this country over the last couple of years due to a variety of factors. And we're the only state that did this bail reform. So I don't know why Chicago or LA or these other cities are experiencing similar crime spikes because we did bail reform. Obviously, it's not directly related to that. But the people that don't like what we did are using it very effectively to completely mischaracterize the law.
The part of the legislative process is that if, for whatever reason, even if you don't like the reason, if you don't respect the reason, if it's based on something other than the facts as you understand them, compromise is how the system works, right? So there were the 2020 amendments to the package that you originally got passed, and I wanted to drill down on a particular phrase. It makes people eligible for bail if both a current and a pending charge involve, quote, harm to an identifiable person or property. What's the origin of putting that in as an amendment? What was the fight about there?
Yeah, and you're right. The sausage making on this, as with most laws, it takes you in directions you may not have originally intended. I mentioned the original bill got rid of bail in every instance and replaced it with a different process. What we ended up with was something that mostly got rid of bail for certain categories of charges, and we started calling it the bail bucket in terms of the negotiation. And then the 2020 amendments were primarily about adding additional charges to the bail bucket. One of the things we did, because we constantly are trying to listen and actually accept good ideas and make changes when necessary, is this idea of repeat offenders, people who just cycle through because they're not being held, are just committing the same, or accused of committing the same crimes over and over again. And so the idea was, if you're out on a charge and you're pending trial and you're charged yet again with something that would be harmful to a person or property, that you can then be bail eligible. Interestingly, that those words, we thought we knew what they meant, but judges kind of looked at it differently. And so I think we had always, in those 2020 amendments, intended to capture like the person who keeps, robbing banks day after day while they're out. But it was not harm to property was not interpreted to include stealing property, and so the changes we made this year clarified that.
And the clarification says what? That it's, well, in effect, at least the way the judges are interpreting it, it's capturing a lot of misdemeanors, right? Repeat misdemeanors?
Yeah, but only certain kinds of misdemeanors, right? First of all, we never go below a misdemeanor because the actual maximum sentence after conviction of a B misdemeanor lower is less time than you'd get waiting for your trial at Rikers. So none of those are in the categories we're talking about. But what we did in this year was we defined harm the way we intended it to be defined. So we made it clear that theft of property is included in these repeat offenses that would be bail eligible.
At the time that the main body of legislation was being done, the governor at the time, Andrew Cuomo, weighed in. The mayor at the time, Bill de Blasio, weighed in. That's where, in my memory, serious talk about adding, fundamentally changing the law and putting in a dangerousness standard started to be heard. Were they, I don't want to use the word posturing, but were they sort of just announcing a position, or were they serious about trying to persuade you to fundamentally change the way New York does bail?
It's a good question. The mayor had his position, but didn't really influence the conversation very much. This was, as we discussed, this is something that had been getting discussed and thought about for years. And yes, I think former Chief Judge Littman had a whole report that also advocated for dangerousness. This dangerousness question has been raging long before we've started having this conversation. It has been a subject of serious debate in New York policy for a long time, and it had been settled decades ago that we weren't doing that. And then in the effort to reform the injustices of bail, I think people who have that point of view saw it as an opening to reintroduce that as part of the discussion. In the end, Andrew Cuomo signed, obviously, what we came up with, and so he didn't hang on to that position terribly strongly. But the mayor, this is a statewide policy. The mayor is always an important person, important local leader, but I think many mayors have been frustrated by their lack of the influence they would like over state laws, and so I don't know that the Mayor de Blasio was terribly influential one way or the other.
The Khalif Browder case that you mentioned is one of the sort of the founding issues that led to some of the reform efforts. There were a lot of different problems there. There was also a speedy trial problem, for sure. In one of the early versions of the legislation, you included maximum detention time limits. It would have been 120 days for people charged with a felony, 30 days for a misdemeanor, very aggressive schedule. I'm looking here, and it says as of May 5th of this year, people at Rikers before trial had been in jail for an average of 325 days. Why did the maximum detention time limits, even something less aggressive than 120 days, why did that fall out of the legislation?
Because of the sausage making is the short answer. Look, speedy trials or speedier trials would solve a lot of the problem we're discussing. The fact that people have to wait almost a year on average at Rikers Island for their trial is a big part of the problem. If the detention we're talking about was a few weeks before your trial, that's a very different conversation than people who, Khalif Browder, 3 years, right, at Rikers in the extreme cases. But the system doesn't have the resources, is not geared up to handle things that quickly, particularly now with the pandemic having shut the courts down for so long. They're still catching up, from what I gather. But even in 2019, some thought that those were impractical time limits.
You've done some, the legislature has done some discovery reform. The mayor has expressed publicly a great deal of frustration with other elements of the system, including the courts, and whether or not they're moving cases quickly enough. Is that an area for future conversation about reform? Is that something you're looking at?
Well, we enacted discovery reform as part of the criminal justice package in 2019. We amended it just this past year, but there's an example, a good news story is all sides agreed on the changes we made this year, and so both the prosecutorial and defense bars, we're happy with what we ended up with. And that's ultimately, look, legislation works best when it's done that way. You do something, you find out what people like or don't like about it, and you make changes that make sense. On bail, we can't agree on having an honest conversation about it, and that's the problem. And you have circumstances where, as we speak, crime is a concern in New York City, obviously, for so many of us, and people are, in our line of work, are always finger pointing and trying to avoid getting tagged with it. Mayor Adams is out there, just yesterday, I think, trying to make sure he's not getting blamed for not doing anything about it. So he's blaming Albany, he's blaming guns, he's blaming, and there may be elements of truth in all of it, but everyone is pointing at bail in a way that is so frustrating. There was a story just a few days ago in Rochester, the Monroe County Sheriff, I think it was, and the headline and the entire story made absolutely no sense. It says, "Sheriff blames parole bail reform for increasing crime." I don't even understand what those words mean all put together. Like, if you're out on parole, you're not in a pretrial bail situation. By the way, if you're out on parole, no matter what you do, you're bail eligible if you're charged with something else. But it's just become the thing that everyone throws the mud at to get it away from themselves. Why is the clearance rate so low? Someone should ask that sheriff. Why are they only solving a certain percentage of crimes in New York City? It's a very low number. 30% of crimes are solved. That startled me when I learned about it. That means if you're wanting to do something you shouldn't be doing, if you want to break the law, you got a 70% chance of getting away with it. That seems to me to be much more a factor in people's minds than whether they may or may not have to put down some money, if they may or may not have, to avoid a few months in Rikers while they're waiting to actually get convicted or not. Like, I don't know that someone who's thinking about committing a crime is calculating all that so much as, I might get away with it. That's the bigger factor to me.
Right. Well, in our last few minutes, I mean, there are the facts that we're going to hear about later in the conference today, and this being a institution of higher learning that has top researchers and can sort of crunch the numbers up, down, and sideways. We'll get to the bottom of that. But you're in a world where there are political facts, right, in an election year. And if the political fact is that voters are concerned about rising crime and are going to punish at the polls anybody who doesn't sort of do something about it, it sort of creates facts on the ground. It creates a governor who says, we've gone too far, whatever that means, and we've got to make some changes. It creates legislators, I'm sure people in your conference, who are saying, look, I got to say something, I got to do something, I can't sign on to this. What does that mean for the existing reforms and whether or not their intended effect on the system is going to be cut back or continue?
Well, look, we've now had 2 rounds of this subsequent fight from the 2019 reforms, and we have drawn a hard line. There was a problem we all identified. Even our opponents on this issue agreed that there were problems with the system that has existed in 2019. We are committed never to do anything to take us backwards from there, and that's why this dangerousness question keeps coming up. Imposing a dangerousness standard when we've never had one, that would be like rewind to 2019 and go backwards in time to make things more regressive instead of more reform-oriented. So to the extent people want to keep having that conversation, they can. They bludgeoned us with it in 2020 in our campaigns. Ron Lauder spent $5 million trying to beat up our candidates. The PBA in New York City spent $1 million in Nassau County in a race to try and beat us, and we came back with a supermajority. So obviously it's a different political climate now. We could talk about redistricting another time, but we don't know what our lines are going to be just yet. We'll do our best to make our cases. We always do, but that's our system. That's democracy. I think money is too influential in our democracy, but nonetheless, we fight the fights, and we've been pretty successful in the Senate with a lot of opponents over the years.
What would you say to the many, well, there's a combination of scholars and students and activists and other people who have some influence and want to be part of this conversation going forward? What would you urge them to do to become part of this?
Well, there's a number of organizations that are involved on this issue, and I'm sure John Jay can point people to the right ones, but we have, and I don't want to pick individual ones I would direct people to because there's so many good ones, but if someone wants to reach out, we can, and I'm sure John Jay could do this too, point them to any of the multitude of advocacy groups that are working on this and other issues. But there's not not a dearth of them. There's lots of them.
You know, one way to interpret all of this, I wonder why I never hear, or I haven't heard more from you and some of your colleagues. It's like, this didn't just fall out of the sky. You all were duly elected. I couldn't introduce you because of the current circumstances as the senator from, you know, some set of neighborhoods to be determined. But if this reflects the supermajority will, as expressed through the voting system, you know, despite the amount of noise or intensity or arguments made by other people, you, I think, probably have some basis to say, this is what the people of New York said that they wanted. They elected us. We went through at least one election from the time that we started talking about this in 2020. We're going to have another one. Will you feel like your efforts have been ratified if you come back with a supermajority next year?
Well, I think our efforts have been ratified by coming back with a supermajority in 2020, because we had the kitchen sink thrown at us on this issue specifically. But again, I try not to get too worked up about it. This is our process. This is our system. People get to run against our candidates and make whatever argument they think works. We defend what we've done, and the voters have the final say. And so we'll do that again. We've been very successful. We have the largest majority in the history of the New York State Senate right now. And so I think we're doing something right that the voters appreciate in order to kind of get into that place.
Okay, that brings us to the end of our time. Thanks so much for a great conversation.
Thank you, Earl. Thank you, everybody.